Drink in that view. You could look at that for hours and not waste your time. It's absolutely beautiful. I'm out here at the turn of Castellon and Black Gap four-wheel road in the beautiful Big Bend National Park. And I wanted to follow up on that video series that we were sharing with you about hearings in a criminal case. After your preliminary arraignment, the next hearing that most criminal defendants are going to have are going to be a pretrial hearing, and sometimes that's interchanged with just a docket call. But those are hearings where the parties, the state of Texas, through its officers, the prosecutors, the district and county attorneys of the county in which the defendant resides, exchange the information that they have and any information that may be within their conceptual custody or control. So something gathered by law enforcement is something they probably have, and you can make an argument under the Michael Morton Act 39.14 of the Texas Code that pertains to criminal justice that you should have access to all that information. So depends on the court, sometimes 2, sometimes 4 pretrial settings or docket calls. And then there's going to be a trial setting. And prior to that, there's going to be a contested pretrial hearing. And that is where the state and the defense attorney, whether court appointed or the private hire attorney, are going to argue about things that they still lack in discovery or things that they need. And sometimes that's witness statements, identity of witnesses, matters regarding restitution, things that may have not been produced in those pretrial proceedings that have been uncovered later. And those contested pretrial hearings, at the conclusion of those, you're essentially left with 2 decisions: either going forward on a trial setting or reaching an agreement with the state of Texas about whatever that defendant concedes their criminal responsibility to be. And it's not as much a matter of the state says you did X and you can agree to a punishment range of doing Y, but also because, you know, there's a burden of proof. It's a very high burden of proof, and that's one of the reasons why the state of Texas is generally very good about negotiating with the criminal defendant in order to resolve cases. And about 96% of criminal cases resolve in those pretrial hearing settings, docket call settings, of which, like I said, depending on the court, you might have 2, you might have 4 of each. But after that, it's going to be time to make decisions about, can you live with the offer, or are you going to put your fate in the hands of the jury, or are you going to proceed with a bench trial? And then there are other decisions that can be made. And I'll get to those in the next series. Thanks again for watching. Like, subscribe, and share. I'll see you on the road.